We are live. Hello and welcome, everybody. David is with us from Manifest team, and he's one of our immigration lawyer. Before we get to him, we do this every single Wednesday, 1 p.m. California time, 4 p.m. Eastern time, and we answer any immigration questions you may have, and then we try to update whatever is happening in the world of immigration. And David, last week there was a good news, at least I would say, in terms of visa bulletin and what's happening, and a lot of people were happy. And there's like also speculation of retrogression, if it's going to happen, if it's not going to happen, why did this happen, will this continue to keep happening? There's so many questions, so maybe let's dive into that. But before that, maybe do quick intro for anybody who may have not seen you on the channel.
Yeah, sure. Well, thank you again, Yuri, for having me. My name is David Santiago. I am Senior Immigration Counsel here at Manifest Law. A lot of my background is, well, all of my background is in business and employment immigration law, but really been focusing on corporate or employer-sponsored accounts. That goes from O1s, L1s, TNs, and then also green card cases from perms to EB1As and EB2 NIWs. So I'm just happy to be here.
Nice. Awesome. David, why don't we start with visa bulletin? Why is everyone happy? Why is everyone celebrating? Why do everyone say that? Is it good news or not? Yeah, and then I have a bunch of follow-up questions, but maybe let's start with the headlines. Like, why is everyone so happy?
Yeah, so everyone's happy, the entire world, which is very new, I would say, for all of us, especially all the randomness that has happened, especially in the immigration world. But everyone's happy because yes, the visa bulletin has moved forward for the rest of the world, which is everyone essentially who's not in the Philippines, China, or Indian nationals has become current for EB2 data filing, and it is also moved up a lot for Indian nationals and Chinese nationals. So people who maybe were, especially, I would think, especially a lot of nationals from India and from China who thought they had to wait much longer are seeing advancements that they didn't think they would see in a long time. Especially if you look at the EB2 category, I believe data filing for Indian nationals, it from February visa bulletin to March visa bulletin, and moved ahead 11 months. So it's almost a full year of movement. Why is this incredible? I would say for anyone in EB2 or even EB1 category is basically the reason why it's so incredible, honestly, is just because I think no one expected this kind of jump. I would say I'm one of the more optimistic immigration attorneys, where on a quarterly basis, I think I said this the past few times I was here, quarterly basis, I see movement. I'm hoping at least a few months, a few weeks, if we're lucky. And then we were surprised, right, with this kind of growth or this kind of forward movement, especially for Indian nationals on the EB2 data filing. So
Mm.
basically what that essentially means, especially the data filing chart, and USCIS is utilizing that chart for internal adjustment of status. So if your priority date has been met, where it's before the data filing that's labeled there on the March visa bulletin, you can apply for adjustment of status. Now, the final action date is going to be different. It's going to be a little bit more behind, and you still have to wait for your actual official green card. But if you apply for adjustment of status, you can also apply for a work permit, a travel document, which is called advanced parole. So you can travel if you need to for emergency or personal reasons, and you're not just dependent on maybe your current work visa. You have this also underlying status that is giving you a green card. It's not just giving you a green card. You're already in line. You're just waiting for the actual green card.
Mm.
So I think there are so many benefits to this. What I'm seeing, I don't think this was a mistake. I don't think this is going to be an off chance. As we've seen, I think the past year, almost year and a half, there has been so much delays in the visa bulletin. Well, for the past, like I would say since 2022, there's been a huge delay. So the past 4 years, there's been just more and more delays in the visa bulletin for most people. But aside from that, in the past year and a half, it's just been hard to get approvals or vetting processes to be done
Mm.
for the EB1 and EB2 categories, even EB3 as well. So what this is looking like to me is that because of these vetting processes, there were so many immigrant visas available, that on the EB1 category, there was some movement, but
Mm.
especially on the EB2 category, it seems like it pulled over, it like spilled over and really jumped people ahead, which has been, I think, really a nice surprise from the many surprises that we've gotten recently that have not been so nice.
Should people start um, assuming that this is going to continue to happen, or this is like probably one off?
I think honestly, it will still be happening to the level that it occurred, for the EB1 and EB2 categories. I'm not sure now. I'm not sure. Before I would, like I said, I was thinking on a quarterly basis. Maybe I knew March was coming, so I knew something was going to move forward, but I didn't think it was going to be this much
Mm.
forwardness current. Where even for the rest of the world, it's current for EB2. That
Mm.
hasn't been a thing since 4 years. The advancement of almost a year for EB2 Indian nationals. That I don't know when the last time that happened. So I I think there's going to still be movement. I hope now on a monthly basis. That's what I'm hoping for. And what I'm also hoping for is that the final action date moves ahead a little bit more now. What I'm starting to see is maybe they're clearing the backlog because there have been much more denials, especially in the EB2 category. EB1A there has been percentages overall, right, from USCIS, that has been overall less, amount of approvals, higher, like a same amount of caseloads or higher, but less approvals. And for the EB2, there's been a high volume of them, but a lot of denials. So I think because that's being cleared out, now they're saying, okay, the people that actually have these approvals already through a sponsorship, through an EB1A, an EB2NIW, there's there is movement for them. They should be getting green cards sooner rather than later because now there's so many immigrant visas available compared to when a lot more people were getting approved before. I did not see movement though at the EB3 category for data filing for Indian
Yeah.
nationals, from February to March, if I'm not mistaken. So what I would really recommend is now is the time, if you can, to maybe seek, in EB2, whether it be a sponsorship, a classification for EB2, or an EB2 and IW, and port your date and port that priority date that you already have. See if you qualify and try and attempt it. Have a consultation with an immigration attorney. See if you have strong points, or see if there's anything also that you can do to make your case stronger so you can qualify. The benefit of already having even in EB3 is that you have that priority date that can be ported up or down if you need to, but most likely ported up to get your green card faster.
Mm. Okay. And then there's another speculation,
Mhm.
is that it could be because of the ban that was put in for 75 countries. That's why this happened. Do you feel like that could be the reason?
I mean, I think all of these factors, but I think it's the higher scrutiny that's happening on the USCIS level, not the ban of processing specifically, but I think that technically helps because there's less less adjudications, less approvals, or
Mm.
denials even
Yeah.
happening because there are cases that are being just paused, or immigrant processes outside the United States being paused. Banned countries can't apply for any type of process inside the United States either. So there's a lot less of that now. So because of that, more immigrant visas will become available for countries that are not banned.
Mm.
So I do think that it's a factor, but I definitely think it's also now because if you remember January, um, like 2025, right? It was everything was kind of, I feel like, stopped or backlogged. Everyone was getting RFEs for their EB1s or EB2 and IWs because of the change of administration and because of the USCIS officials refocusing their guidance based on the Trump administration. Um, so I think there was so much backlog that they're just doing everything in their power to try to clear who they can clear now.
Mm, gotcha. Yeah, I think we kind of covered this. Is it possible that backlog for EB2 Indians will decrease in coming months, years? I mean, we are already seeing it, but I don't know. What do you think?
Yeah, I still, like I said, I think the growth or the priority date, the date of filing for the visa bulletin for Indian nationals, maybe for the EB1 category, will still come, but it'll be slower growth and growth happening. But if you see how backlogged, right, EB2 Indian nationals are, it's, I think personally, right, the basically it jumped 11 months, and it's still pretty backlogged. I think it's November 1st, 2014. It's the date of filing for Indian nationals for the EB2 category. So and the necessity too, and the people that have these approvals already, there should not be such a great backlog if there are immigrant visas available. I think it'll still be moving forward. I think the visa bulletin will keep moving forward. Maybe not another 11 months, but maybe I'm wrong. Maybe in June, the June visa bulletin will come out again, and it's going to be 2015. You never know. So just in case, because of that, and because the new visa bulletin doesn't come out, yeah, for another few weeks, um, maybe if you were considering applying for an EB2 and you already have, especially I feel like if you already have a priority date with an EB3 or unskilled work, whichever EB3 priority you might have, then you should try it.
Mm. As an Indian, if I am in EB3 category, because of this bulletin movement, should I move it to EB2 if I have the option?
Well, I I would say that you should definitely consider that just because there was that's the thing with EB3 though, with for Indian nationals, there was no data filing movement, right? From February to March.
Yeah.
So what that shows me is that USCIS, this current administration, just which makes sense because they were really idolizing this gold visa card for EB1 or EB2 categories. It seems like they're really prioritizing professionals in EB1 and EB2 categories from any country that is not paused or banned at the moment.
Mm.
Because of this, I would say, if as an Indian national, um, may from the growth that I'm seeing, from the trends that are surprising, especially for March,
Mhm.
to consider doing that. Consider getting an EB2 sponsorship or an EB2 IW. Obviously, an EB1A is great too, but um, something that maybe is more realistic for a lot of people, because also I think a lot of people don't understand how impactful their work is for an EB2 and IW, for example, that they can really show um, the benefit that they'll bring to the United States, and then that approval will not just benefit the United States, but they'll benefit them because their priority date they could just bring it up a way higher. I am worried though about the kind of like the lack of movement though on the EB3 and below side of
Mm.
things.
Yeah. Yeah. And EB1 is obviously, EB1As are obviously still going strong. Is it oversaturated, do you feel? Because now everyone is wanting to do EB1A.
That's, I think, a great question. So, well, the benefit is there was a 4 month movement on data filing for EB1A for Indian nationals. So, because of this, I think that there is not an oversaturation yet, but with the movement that's happening, and also with the recent district court decision in Nebraska, I believe it was McCurdy versus Miller, where they found final merits determination to be arbitrary or unlawful. right? They found that the second step of the Kazarian, right, of the Kazarian analysis, aside from the criteria, that based off of these criteria, overall, with all the documentation, all the information that you have, does this prove that you have sustained national or international claim and that you're in the top percentile of your field? The officer has to assess that. That is very subjective for, especially for technical parts of a professional. But that now is being argued. Not, it's not law. It's not something that can be used for all EB1A cases, but it's something that we can try to argue in case new cases for EB1A. I see this trend though happening where people are going to try to argue things and then they're going to try to say, hey, I know I fit for an EB2 better, but I want to go for an EB1A. I could see that happening like in the later end of this year. Um, but I that's the thing. So not I don't see oversaturation right now, and also because there's been a decrease in approvals starting since last year, for USCIS in general. I don't see it yet, but I think that might come.
Mm, got it. Perfect. And I just wanted to remind all the people who are here that if you do feel that you're on the path of EB1A or O1 talent visa, uh, either of one of them, I've just posted the link. You can get your profile evaluated with Manifest team, and you can also get 30-minute free consultation, and they can tell you where you stand and what the next steps you should be taking. So definitely take advantage of that, which is probably something everyone should be thinking about and not just rely on H1B lottery. Do you agree, David?
Great transition to the H1B lottery. And I completely agree with you, just because you really, I feel like sometimes, especially some 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 clients that are not from the United States, obviously for immigration, all of our clients are not from the United States, but they don't understand how great the work that they're doing or the impact that they've
Mm,
done themselves can really benefit the United States or can really be proven unless they speak to someone that has done hundreds of these cases and is impressed by their work. Hey, I've seen STEM professionals, non-STEM professionals, entrepreneurs, business, social sciences, health like professionals all be approved with EB1As or EB2NIWs that at first were unsure. They didn't think that the work that they were doing or the impact that they've done, the recognitions that they've received, or the work that they've actually been able to implement was something that was at that level. But then when you really place it in a perspective, it is. So yeah, I
yeah,
would I would suggest that.
amazing. Link is again posted, so feel free to grab it. But we will get to Q&A. Lots of questions are already lined up, so here we go. Was previously on H1B, did change of status to B2 approved, and did change of status in premium processing to F1 also approved, got approved in less than a day. I guess here's the question. My H1B stamp is expiring soon. In case I get a job after my H1B stamp is expired, can they approve my H1B and ask me to get an H1B stamp? Currently on F1 day 1 CPT, I-94 expiries TOS.
Okay. Okay, can I get a job? Yeah, at first, Kieran, I thought you were just bragging. No, you got approved today. I'm like, congrats. So I would say if you're doing, because this sometimes happens with cases. This sometimes happens also with people where they were on H1B or they had an H1B status. They left or there was termination, there was an issue with the company, and they were on a grace period. They applied for a change of status, and then they applied for something else, like you did, right? Day one for Kieran for the day one CPT. I think if you're able to get a job and not, I think that the caveat here is don't get a new or don't try to do this maybe through consular processing as of yet. If you're able to do maybe a change of status back to H1B while you're still inside the United States, you're here under F1, you've already been counted against the H1B lottery previously, and you have your current H1B status. I think that is a possibility. It's worked before for clients of ours where had an H1B status approved. For some reason, they couldn't maintain it past the 60-day grace period, so they had to change status. Some other status came up, something happened, and then but they were still here in the United States. So I think it's a possibility to be able to change your status back to H1B inside the United States. And then once you do that, then you can go and get a visa stamping, right, for with your new H1B approval
Mm.
without the 100K fee.
Yeah. Okay. Received ASC biometrics, digital photograph appointment to expedite the process. Can I appear at ASC center before and ask if they can get my biometrics done early? Will that affect anything? And what can I submit after my ASC appointment is done to respond to related RFE?
So for any USCIS or any honestly governmental establishment, I would not just go in early without an appointment because they're not going to see you most likely. Normally when you have to go into any institution, any office, especially any of the field offices or any office that does anything like that, you would need an appointment. So I don't think going in and asking is going to work. I don't, it won't impact your future biometrics appointment. But I think you attempting to go in is just not gonna work. And I think the other question was, is there anything that can be done prior to prevent RFE or for an RFE?
Or
So
it was more like if once the appointment is done, what do they need? Is there anything else they need to submit?
no, I don't think so as of right now. Don't I would say don't you shouldn't preemptively also like send stuff afterwards unless you get an RFE. You don't want to confuse an officer.
Mhm.
So I no, I would say just make sure. And this, I'm sorry, was this for an F1 or was this what was this?
I'm assuming OPT. They
OPT,
haven't
right?
mentioned it.
Oh, they didn't mention it. Okay, yeah, I'm assuming that too. Yeah, no, don't. There's nothing really ill. It might. I would say don't do anything additional, going in early, sending additional stuff after you do biometrics until it's asked of you, because then you might cause delays sending additional things. I like I said though, I don't if you try to go in early, I think they'll just reject you and tell you you can't come in, but that won't impact you. But if you try to send things to the officer or if you send things to USCIS early, or preemptively for no reason, then that might just confuse the officer. I would
Mm.
not recommend it.
Okay. I've applied for my EAD card. I still get any approval. I still haven't gotten any approval, nor anything is pending from my side.
Okay.
Um, yeah. I,
That's been common. I'm assuming it's for like an EAD OPT card or yeah,
yeah.
so that's been very common. I've been seeing that a lot more and more recently where people have been waiting they way past the normal processing times. My steps of recommendation would always be to check the current processing times that you see on my USCIS. If it's past the time, then you can go below the processing times, add your add your receipt notice or the date of filing, and then after that, it'll say you're eligible. Send a request for a follow-up to USCIS. You send it, but if you still haven't heard anything yet, then contacting USCIS might help. If you can upgrade your process, if that's what we're talking about OPT to with premium processing, but there's it's hard. It's hard because the only guaranteed way to get a response for a process is through premium processing, right? It's through that additional payment that is going to go up again. Don't forget everyone, after March 1st.
Yeah. Okay. Graduated with Bachelor's of Arts, Interior Design 2010, MSc in Strategic Design and Management 2023. Am I eligible for EB2 National Interest Waiver? My OPT ending July 2026. Um,
Well,
yep, sorry, go ahead.
no, 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 no.
I was just gonna say, Jyoti, feel free to apply to that link, and
Yeah.
you may be able to just get your profile evaluated.
Yeah, no, I agree. I mean, you are viable for it, but that's not enough, right? Especially if we're thinking EB2 and IW. and I tell potential clients, current clients this all the time. The two most important things are that this proposed endeavor statement that you're going to implement has national interest points, something that's going to be beneficial to the United States, and you can prove it, and that you show that you're well positioned or you're the ideal professional to carry out this proposal here in the United States. So yeah, there's going to need to be a deeper dive for that. But if you're also trying to file that and your OPT is ending this year and you are an Indian national, then you would have to worry about staying. The EB2 and IW, the I-140 petition in it by itself does not give you eligibility to remain and work and stay in the United States. It's just a direct path to green card when you can. So, Jyoti, if you are an Indian national, then you have to also consider other factors and other work visas. Maybe look at the H1B that's going to be open next week, or there's an O1 visa, which is, I think, incredible. It gives you also a way to work and remain in the United States.
Perfect. Okay. I see this comment multiple times. Do not see the link. Vivek, I think because LinkedIn does not allow me to post the link while we're on live stream, I will send you a DM right after this so that way you can get that link. So sorry about the process. Here we go. I'm currently on F1 STEM OPT, valid through July 2027. I am currently on my unemployment days and have around 30 days left. I've enrolled into a master's degree, the classes for which begin on March 14th. If I transfer my SEVIS now before 30 days end and then later decide to defer the May intake, as that will help me get 2 H1B attempts. And that's a question.
Yeah. Hmm. That's a lot of days. That's really close in time. I think that's the kind of thing that I'm only kind of worried about. Like the days, right? So you transfer your service now before the 30 days end, and then later decide to defer to the May intake instead. Okay, as that will that help get me to 2 H1B attempts? Uh, I mean, valid through your semi-PT valid through July 2027. I mean, you'll I still believe if I'm doing the math right, but if you're just transferring your service now, you're going into a different program, or if you're enrolled into the master's degree, um, the validity or the extension of your STEM OPT will still be in the parameters of the cap gap if you apply. So, you should be able to do that regardless, the 2 H1B attempts, unless I'm not doing the math correctly.
Yeah, maybe Suchita, if you can rephrase this question, it might be helpful.
Yeah, or give us more dates, or do a consultation with us before we start. But
Yeah, that too.
yeah, no, yeah.
Okay. I'm currently on STEM OPT that expires in June. I have been working full time in remote, hourly paid role. My employer now requires me to move out of state to work in office if I want to continue getting paid. I'm not being sponsored. He suggested keeping my PAN active and making me on vacation until my OPT ends if I don't relocate. What's the safest option? Relocate briefly or take time off? Okay, this is interesting.
Yeah, I'm
uh,
not being so they're not being sponsored. Maybe they mean like well, because they're under STEM OPT, but they're not going to be sponsored maybe
yeah, they
for
are not
anything.
gonna sponsor
Do
H1.
H1B, got it. Okay, so just keeping my PAN active. I don't know what a PAN is though. I'm trying to remember what a PAN act. Okay, and marking me on vacation until my OPT ends if I don't relocate. Marking me on okay. Oh, okay, so marking you just off on okay. What's the safest option? Relocate briefly or take time off? I mean, my employer now, if your employer is now requiring you to move out of state and to work in office, did they do this? They first don't they need to notify the DSO. They need to notify the actual university that this is happening. And the if you are working remotely and if this is in the university, your job is normally maintained. Like if you're saying you're remote, it can't be dramatically changed unless they let the university know. That's the first point that I'm seeing kind of just outside of these factors that is kind of concerning to me. The safest bet would just be to take time off overall. That is the safest bet because it seems like this employer is kind of giving you just like ultimatums, which is not it's not for STEM OPT purposes, it's not beneficial for you because you'd have to relocate briefly and work in person, but also legally speaking, this is something that they should not be able to do. So um what I would suggest is, yeah, take time off. Maybe um, find another employer that would sponsor you for the H1B.
Yeah.
Maybe that could be a good recommendation, or even look at the O1 as well.
Yeah. Yeah.
That's tough. That's a tough situation.
Yeah. What's the real difference between date of filing and final action date, and which one actually gets me green card?
Okay, that's a good question. So, final action date is when they'll actually provide you the green card within the United States, right? So, the date of filing is the date when you can apply for adjustment of status. When you can file your I-485 with a work permit, the I-765 form, and the travel document, which is advanced parole I-131 form, all together, and you can use these based off of your approved EB whatever, right? Or
Hmm.
your approved I-140. Um, so with adjustment, that date of filing is earlier than the final action date. Final action date is when they will actually provide you the green card because usually rest of the world, usually the dates are current or maybe the date of filing is current, but the final action date is still behind because it takes some time for them to process the actual adjustment of status. Normally, you before it used to take like if you're current, it used to take 6 to 9 months. Um, Now, obviously, it's taking much longer for people, um, especially I would say for Indian nationals, right? Because of the waiting times. So I would say getting your actual green card is final action day. That's when you can look at it, when you'll actually see processing, and then they'll send it to you, or the small chance that they'll ask for an interview. They'll ask you for an interview right before they are intending to give you the green card. But then date of filing, I would say, is actually the more important date because that's the one that USCIS uses to allow you to apply for adjustment of status and to maintain authorized stay here in the United States.
Hmm. Okay. If my employer withdraws my I-140 after I file I-485, am I still good?
Only if your I-485 has been filed for more than 180 days. So that's kind of the rule with that. If not, and if they are withdrawing or if they intend to withdraw, then you should try to find another, you would have to probably restart the process with someone else if it's a sponsored based I-140 and
Hmm.
I-45.
Okay. If I change jobs after filing I-485, how do I really know if the new job qualifies as same or similar?
I think that's a really good question because that's a little bit of a, I would say, a vague statement, right? Same or similar classification or occupation. Um, Obviously, you're not, if you are a software developer and then you decide to work in a bakery, then that's not same or similar, right? You have to be logical about this. But if you are doing something in software development, but you're doing a new role that also includes web development or architectural innovative processes,
Hmm.
um, then I think that is enough. That it makes sense. It overlaps, and it makes sense to use, right? Or it makes sense to implement. So I would say that overall, the same or similar argument, you just need to make sure that you're the same field, right? Same field or similar occupation.
Hmm. Hmm. And I guess maybe it's a similar question. If I filed Sorry, this is a separate question. If I filed I-485 in 2022 and I'm still pending, does this new bulletin change actually change anything for me?
If you filed your I-485 in 2022, okay, so
I'm assuming
what?
he's Indian from the name.
Yeah, I'm assuming I'm trying to think of it. If not, I'm assuming yes, I'm assuming Indian because of the name, but I was trying to think of the category. Data I-485. But
Um,
also, how would you be able to file the I-485 if you're not ready, if you weren't ready to, they would reject it if your data filing wasn't ready yet. So that's what if I filed the I-485 in
I'm
2022,
assuming he means the priority
uh,
date is in 2022.
or maybe he filed it, his priority date has already been hit, but the final action date. The final
Mm,
action date, yeah, I think that's what's kind of, I'm assuming that's what's being mentioned. I would hope that because yeah, so the thing is though the final action date for the EB1 only moved a month for Indian nationals, right? And then the final action date moved like I think
I think they should just rephrase their question.
yeah, like a few months. Yeah, it depends. Yeah, let us know. Yeah, I think we just need a little bit more information because if they're EB1A, it's only moved a few months, so I kind of want to know like category wise what they're
Mm,
waiting on, when their priority date was, right?
yeah. If my EB3 I-485 is pending, but my EB2 I-140 just got approved, should I interfile or stay put?
I mean, if you wanted to, because your EB2 was approved, right? And if you want to get your green card faster, then you can file for a new I-485 with I believe it's the I-485J amendment, where it's basically like stating that you have this process already going, but now because of your new EB2 approval, you want to port the priority date that you had for EB3 to your EB2, and then classify you under the EB2 category, so you are able to speed in the process up more. That's a possibility, and it depends obviously on the priority date that you had with your EB3, but that should be able to be a faster process for you and your family to actually get your green cards.
Mm. If my base salary is lower, but my total compensation is high with bonus and RSUs, does that help under the wage based system?
Unfortunately, not. So they are just looking at, and obviously also we're not going to officially 100% know until next Wednesday at noon. But because what they're basically stating is base salary. Standard company benefits or standard compensations um, are not even a factor yet for the actual H1B lottery registration. What they're looking at is overall base salary that cannot be changed. I think that's why really they're not looking at benefits or compensation, because that is it's very subjective, and it's on a case by case basis. It can go up, it can go down, things can happen. So because of that, the US government is really focusing on, aside from the worksite location, but the wage salary that's based on the worksite location. So that is not going to help at the moment. But also, I want to remind everyone that it's based the wage of this job that that you're registering for now or next week is based off of an approval that's going to happen based on the wage that you will have in October 1st, right? So there might be some room to discuss this with your employer.
Mm,
Some employers are really understanding of this. Some other ones are not. They're confused. They're like, wait, I thought because we're registering now, it's whatever they're being paid now. No, it's you have to base it all off of the job position, the SOC code, the location that's going to happen starting when your H1B is going to be utilized on October 1st. So really consider that. Sometimes when you also let your employers know that, they're a little bit more willing to provide something, because almost everyone is entitled to some kind of raise, right? Or benefits later on, later in the year. So why not preemptively plan this now with your employer?
Mm. Yeah. Okay. The follow-up, since I'm unemployed on F1 STEM OPT and have only 30 days of unemployment left out
Hmm.
of the 150, I've enrolled into Day 1 CPT Master's program, which starts on March 14th. And later, if I find a job that will give me only one H1B attempt, as the program will end in 2 years, hope that clears why I want to defer to May, or will that be illegal to stay from March to May?
Oh, okay. Okay. Yeah, because I kind of the only thing that I'm worried about is that if you defer or what the only thing I'm worried about is that you only have 30 days left, right? And then
Mm.
if you defer, and that's going to be from March to May, it's going to be regardless, it's going to be more than 30 days. So what I'm worried about is that these days of deferment get reverted back to the days when you are also unemployed and you're just not having no status. And I don't want that to have any issues with your day one CPT master's program or later on for your H1B. What I would recommend, even though you're going to be close in time, right, to the actual status that you'll be ending with, is to try to be, but regardless, you don't want to do anything unlawfully or things that might potentially cause problems. I have seen people getting questioned for their F1 or day one CPT or STEM OPT being questioned about smaller things. So this timeline is a little bit worrisome. What I would recommend though is that you also speak to one of our attorneys that really focuses on STEM OPT to kind of give you maybe a little bit more guidance.
Hmm. Yep. Okay.
It's
I
tricky.
have 88 days of unemployment left from my initial OPT, and currently I have my STEM OPT application pending. I have another job offer and considering switching while my application is pending with a 10-day gap. So, wanted to know if I can use my unemployment days from initial OPT.
So, okay, you have 88 days of you should be able to, especially if what basically you already and okay, so and you have your STEM OPT pending, and there's going to be that time where you have like that the time pending as well. Considering switching while my application is pending with a 10-day gap, so wanted to know if I could use my I don't see an issue with that. You would just need to notify obviously your DSO, and you would just need to be very clear as to the dates and days. But that I don't see there being an issue.
Yeah. Okay. And I plan to relocate before my start. Is moving before H1B lottery March 19th deadline advisable?
Yeah, I think that's fine. If I plan to relocate before my start. Okay. So, yeah, I don't think that's a problem because remember the H1B, the registration of it is connected to your employer, not you yet, right? Not the person that will become the employee. There is a company that is applying for a job or that is seeking a job that want to be registered in the H1B lottery. Then once they're selected, right, then they have up until or before June 30th to find the best applicant in the specialty occupation to apply for this person. And the job, right, the H1B status does not officially start or trigger until we're at the beginning of the fiscal year, which is October 1st. So that should not be a problem because it's not connected to you yet. And yeah, so that I don't that's I don't that's not going to be an impact to the actual lottery or you being selected for it. However, obviously, you can't change worksite locations afterwards. It's set. It's set what you place in the lottery.
Hmm. Yeah. Okay. If I get laid off during my 60-day grace period, is filing B2 really the safest option, or are there better strategies?
I mean, better strategy would be hopefully you get another H1B. That's the best strategy, right?
Yeah.
But or no, but any other, in all seriousness, it's very common for this to happen. Um, I would say there's no the only thing that I'm worried about with the grace period with during this administration, honestly, is that I haven't really seen it with a lot of H1B holders. Um, but I have seen it with some other non-employment that I've heard of, not with my clients directly, but I've heard of rumblings of other people's non-immigrant grace periods starting and then them being sent a notice to appear by the immigration court.
Mm.
So because the
Yeah, I
being
think there was a
basic,
time for like NTAs were being issued, like
yeah,
for like for a few weeks, and then it stopped all of a sudden.
yeah, yeah. So and it's still might like minorly, like very subtly. I'm not trying to scare anyone, but I'm just being very honest here and practical. But like, you hear rumblings of it, one client here, one client there. So like again, thankfully this has never happened with any of our clients, but um that's the only thing I'm worried about because some people, as if people sending an NTA during a grace period is ridiculous, and you just have to really send the I-94 and explain the situation,
Mm.
but that's still a scare. No one wants to go to immigration court. I don't even want to go to immigration court. That's why I just do employment-based immigration now. So, no, they do really hard work there, criminal immigration attorneys. So a B2 is a safer option because it's an underlying status, right? It's better to have a grace period and an underlying status than nothing. So, or just waiting for your grace period. I always say that. There's always better to have something else, especially I think a really great benefit to someone who maybe just recently got laid off is that they have already been counted for the H1B. So there's no H1B lottery, there's no 100K fee. Reiterate that to any potential employers. And if you guys need any help, of course, we're here for that.
Yeah. I'm Indian, currently on initial OPT until June 2026. Can I apply to STEM OPT without any employer and make use of all my 90 plus 50 unemployed mentees?
Make use of all your 90 plus 50 unemployment days. No, and the only thing that I'm no. Overall, the answer is no. I think there's a lot of, especially with STEM OPT without any employer, and then yeah, you're trying to make use of like all of these employment days. I think it's no. It's a big
He's
no.
saying I have current volunteership until June 1st, but for STEM OPT, you do need an paid. Um,
Paid
yeah,
employee. Yeah. It's different rules than OPT, unfortunately. So I think there's a lot more flexibility, obviously, with OPT than STEM OPT. So yeah, you can't really do that. You can't apply that. You need an employer for STEM OPT.
yeah. Okay. If I work fully remote, which location is used for LCA wage? Company's headquarter, my home address, or client side?
Your at home address. That is what is being used. So if you're fully remote, right, you're not hybrid, you don't go to the office at all for any days, then it's going to be the wage level is going to be determined based on your county, where your home is. Which again, I think in Uni and I talked about this before when the wage level analysis was kind of first coming out, that this would be actually pretty beneficial for some people who maybe work at a really great company based in a very urbanized area, but work remotely in a not so urbanized area, because then they will be able to obtain higher wage levels. So yes, it would be your home address.
Mm. Yep. And after H1B approval, if I move to another state, when is an H1B amendment required and what timing is the safest? And do they still have to do the wage level thingy because they are now already picked in the lottery?
Yeah, this is a great question. So basically, there is a tiny little footnote amendment in this new wage level analysis for the H1B lottery, basically stating that the person, if someone moves a state, um, if someone moves from one state to another where an amendment is needed, especially if you have to move quickly, the the Department of Labor and the US government could consider this as you lied. You lied about the actual wage level because or there was you were misrepresenting the wage level just to get into the lottery, right? So for this specific person, I would first see because if you're doing this during the H1B lottery registration where you already placed a worksite location, but then you say, hey, or even worst case scenario, um, there's a work site like inspection, and you're not there, and then you're in a different state, then obviously that your H1B process is going to be canceled or revoked or denied.
Mm.
So, but if let's say you already have your H1B, and then you was approved, it's past October 1st, but you decide to move a month later, and you file an amendment for that, that is going to cause huge red flags, I believe. I believe if you have to move right after you get the H1B to another state soon, and you should file an H1B amendment as soon as you can, or but because your location is going to change, you're going to change where you are. But if you do that, there's a high chance the earlier you do it, that when you apply for the amendment, that the government's gonna be like, "Are you were lying?"
Mm. That's scary.
Yeah, yeah, that's scary. I would not recommend it,
Right.
honestly.
Yeah.
Yeah, I would not recommend.
What happens if I don't get H1B sponsorship till the end of my STEM OPT? Do I have to leave country or are there any processes to stay in United States?
Um, Durga, you should really listen to UD's previous podcast. No, but so there are so many options out there, especially for skilled professionals, academics. I really think that, for example, right, I really like the O1 because there are many different aspects to the O1. There's an O1 agency where if you have an agency or an agency company that works with you and you have contracts with different people, then that could be a way for you to self kind of sponsor yourself through an agency. Also, if you have your own business and you separate the business from yourself, showing that the business is hiring you and there's different hiring and firing powers from yourself, then you can also file an O1A, even if it's your own company. You just have to divide the company to who you are, or a normal O1, which is sponsored from an employer. So there's so many avenues to that and obtaining job offers and contracts. You just need to fit 3 of 8 criteria. And it's not such a incredibly high standard as an EB1A, even though it says extraordinary ability, but there is still a standard. And you, like I said, always try to make sure you hit more than the 3 of the 8 criteria, just in case if USCIS wants to argue with you on a few
Mm.
points.
If my company increases my salary after lottery registration, but before filing, does that change anything?
Yeah. Well, yes, and it depends on when you let the USCIS know, I guess, or once, yeah. So yes and no, because again, it's not, it's, yeah, I think employers need to remember that it's not data filing solely on when you're actually going to get the actual like selected for the H1B, but when the H1B is approved on October 1st. So because of that, right, you have to really think about the salary that you will be having on October 1st. It doesn't have to be paid yet, but the wage, and if it's going to be higher, especially like significantly higher, then why not try to place that information now, so
Mm.
then you can really utilize that and you can have a higher wage level, and that does not have to be even implemented yet until October 1st. So if you know that your salary is going to go up after the lottery before you get your H1B, and your employer has to provide that information as well. So so your wage level is appropriate and it's higher than what you are currently making now, again, which would benefit you in actually being entered and getting the H1B lottery.
Mm. Yep. Okay. If my job is borderline between two SOC codes, how risky is it to choose the higher wage classification?
I don't believe it's risky to do that. I think that's the whole point of having um like a legal team and doing an legal analysis for this, because if your job position with the job description is truthfully and honestly in between two SOC codes, then why not use an SOC code that makes sense, that is going to give you a higher wage level, right? What's the I don't see a negative. It's not fraudulent. It's similar to the job descriptions you need. It's not something that you're misrepresenting the job or the work that you're doing. It's essentially, if you're going to be paid that level, and it's one of the more similar ones, or the top or the second one, that makes sense to you, to your employer, and to your legal team, then I don't really see an issue with this.
Mm, yeah. I was laid off and I'm on day 40 of my 60-day grace period. Should I file B2 as a backup even if I'm interviewing? That's a good question. Mm.
That is a good question. Like I said, I think always an additional underlying status is important, and it's kind of essential to have. So what you could do is, just in case, right? This is plan B, right? If you apply for your B2 change of status, you have a lawful underlying status that you have applied for. But let's say day 50, right, in 10 days from now, you have an interview, you get accepted the job, H1B process starts. um, while the B2 is pending, obviously this is kind of the only issue that I see, is that this is really close in time, right? This is hitting a lot of close parameters of doing the H1B transfer, right? Because normally with an H1B transfer, you're going to have to file the LCA, have it certified, do the posting notice, right? And then actually you can't start working until what the LCA, the certified LCA says, and file to USCIS. So having a B2 as a backup, I think is going to benefit you, but there's going to be a lot of factors to consider. Should you withdraw it? Should you just wait until the B2 is approved? So, and then after that, should you do your H1B? It's technically then not a change of employer. It's a new process, or it's a new employment, because you went from H1B to B2 to H1B, not H1B to H1B transfer. So there's going to be a lot of factors for you to consider. But always, for currently right now, if you have no official job offer yet, the safest route is to have an underlying status like a B2.
Mm, yeah. Okay. Does Manifest team take RFE cases?
Yes, we do.
Nice. Okay. All right. My company applied for my H1B last year and it got approved 7 days ago after premium processing. I'm working in same company since 2.5 years. Now I want to switch and I believe USCIS will take it as a H1B live. So what is the best time to let it cool down before the switch?
Wow, your company applied for an H1B last year and it just got approved?
Probably because it was normal processing and he probably did
Oh,
premium.
wow. And then they you bumped it up with premium. It must have gotten lost though, if it took
So
like
long. Yeah.
yeah, like what, like 10 months, I'm assuming 9 to 10 months. That's crazy. So, that's I'm sorry here. No, but it's gonna be based off of, I'm assuming if this was your first H1B, right? I'm assuming if this was you registered, you got the lottery, I think that's what it said, or your company applied for your H1B last year, then the date, even though you didn't get it until now, I'm assuming that they would understand this, because things take time and there's processing times. Usually when this happens though, it depends. Some normally, because it states what the LCA says, right? So your priority date, or I'm sorry, your receipt notice or date when the H1Bs started, was most likely October 1st, I'm assuming. If not, or 7 days ago. But I think USCIS would understand. So if you do an H1B change of status, I don't think it's going to be an H1B lie, because they're still going to have to do the LCA, a new LCA, certify the LCA, do the posting notice, and file it. So I don't think there's a cool down period to explain. I think you just need to explain what happened, right? In the H1B transfer, you applied for the lottery, you were selected, you were expected to start October 1st, but there was some delays. You finally upgraded premium processing. 7 days later, you got the approval, and then X amount of time later, you changed employers.
Okay. Right. I think we have two last questions. My STEM OPT ends in July. If my H1B gets selected and approved, what happens after July if my OPT has already expired? Am I allowed to stay and work until October 1st, or do I fall out of status in between?
No, there's a cap gap. So the benefit of the H1B is that there is a grace period that you're given to work and to stay and remain in the United States up until October 1st, right? Up until your H1B is officially activated, I guess technically, if you want to use that. So because of this cap gap, though, you're allowed to stay and remain in the United States. And that should not be an issue.
And you can work as well in that cap gap?
Yeah, yes. The work normally what happens is you can provide like your approval, right? And you can kind of show that it's provided and it's extended. So you can actually utilize that to, especially if the employer wants you to keep working when you had SIM OPT, to remain and to work.
Mm. Okay. Okay. sh- on H1B from November 2024, or November 24, but her employer didn't run the payroll correctly due to budget and project issues, and she only got paid for 6 months. Now she got a new project and want to change her employer. Can you suggest on this? Um,
Sh- Um, sure. I mean, I think we need a little bit more information, honestly. But if she wasn't paid for an amount of time that the salary she was expected to be paid, then she is entitled to back pay, with her current employer. Obviously, that's going to cause some issues with the employer potentially, but there's really
November
not much.
21 last year, she
Yeah.
got unpaid for 6 months.
Yeah, it seems like she would be entitled to back pay for the months that she wasn't paid. And honestly, yeah, so she is entitled to that. She should probably speak to um an employment lawyer for specifically for that purpose, for the to receive her back pay from her employer.
And I'm assuming that he's asking because for the pay slips that he would have to provide for H1B transfer for the
Oh,
new.
yeah. I'm assuming the previous pay slips to show that you've maintained status. So again, you want to put blame on the employer, which is true, right? They should have been paying you and they did not, or the friend. So getting or being ordered to obtain that pay, the back pay, is also going to help on the H1B transfer purposes as well.
Okay. All right. One last question. I'm a software engineer with 6 years of experience, a few conference talks, and one patent. I don't have any major awards. Do I realistically qualify for O1A, or is that not enough?
You don't need major awards. If you have 6 years of experience, honestly, the years of experience isn't as important as the impact that you've done in your work, right? So let's say you've worked 6 years in a company that's been doing hyper growth, that's been working with, I don't know, Meta, for example. Then to me, the work that you're doing, that would show critical role. You have a patent, so you have a few conference talks, you know, maybe aside from that, you have a distinguished role in your field. So critical role, maybe the work that you've
High
been doing,
salary, maybe.
original contribution. Yeah, high salary is a great one. Did you judge the work of others in these conference talks or these seminars that you've been implementing? So I think it's possible. You don't need just major awards. I think that's like an unrealistic bias that happens sometimes where people just say, well, it's awards, O1s or EB1As. No, you don't need that criteria. You don't need to hit that criteria to get it. I think honestly, the more important criteria is for an O1 or even for an EB1A are critical and leading role and original contribution.
Yeah. Yeah. And again, feel free to use the link that is given to you to get your profile evaluated. Definitely see a lot of potential. So maybe this is where you can talk to the lawyer and get it checked. Okay. Cool. David, thank you so much. Hopefully we will talk next week. I know I'm traveling next week, so I'll keep you posted if we are still meeting or not. But super excited to talk to you every single time.
Yeah, it's always a pleasure. Take care.
All right. Thanks, everyone. Bye.